Hello everyone, greetings from Hong Kong. My name is John Reading, and for those who don't know me from previous symposia, I am a senior counsel, or silk, working in Hong Kong out of a set of barristers' chambers called Pacific Chambers. For 8 years I was the head of Pacific Chambers until I stepped down a couple of years ago. In a previous life I was a public prosecutor for 30 years, first of all in Australia and later in Hong Kong. The last 8 years of my life as a public prosecutor, I was Deputy Director of Public Prosecutions in Hong Kong. I have had the privilege of speaking at many a symposia over the years, and it is indeed unfortunate that the 38th annual symposium, which was due to take place in a few weeks, had to be postponed. My thanks to Barry and Angela for inviting me to upload this clip, which I hope will be of interest. Much has been written in the press in recent weeks about Hong Kong's new national security law, but I do not propose to talk about that controversial topic. The message I would like to convey today is that the rule of law remains alive and well in Hong Kong, and that it is in large part due to the existence of a competent, strong and independent judiciary. Further, no matter what station in life a person may have, if they break the law in Hong Kong, they should expect to be prosecuted. I mostly defend criminal cases these days, but I quite enjoy returning to my roots when I have the opportunities to prosecute. The title of this paper, to borrow the name of an Al Pacino movie, is And Justice for All, the Barry Cheung case. I recently had occasion to prosecute Barry Cheung in a fraud case in the district court. He was the first defendant. Trials in our district court are judge-alone trials. Cheung was a prominent citizen, a close associate of the previous Chief Executive C.Y. Leung and the convener of C.Y. Leung's Executive Council, his inner cabinet. I tend to specialise in white-collar crime, and I'm only too familiar with the problems that often arise when prosecuting fraud. In this case, we had a couple of perhaps unexpected but interesting pre-trial issues arise, and I'll come back to those later. In Hong Kong, we have two fraud offences, namely the common law conspiracy to defraud offence and a statutory fraud offence contrary to Section 16A of the Theft Ordinance. Barry Cheung was charged with conspiring with his chief financial officer, a certain Jackie Choi, to defraud Hong Kong's main regulator, the Securities and Futures Commission, or the SFC. In separate but related allegation, he was charged with statutory fraud in connection with a loan he had obtained. Usually, conspiracy to defraud charges concern financial gain or loss, but that wasn't the case here. The type of conspiracy to defraud that we were dealing here with here was what is sometimes referred to as a breach of public duty fraud. It was a conspiracy to cause the SFC to breach its public duty. So what was the SFC's public duty in these circumstances? Barry Cheung had incorporated a company called the Hong Kong Mercantile Exchange, and he had the intention of offering on the stock exchange precious metal futures. The main shareholder of the Mercantile Exchange was a BVI registered company called New Effort Holdings Limited, of which the sole shareholder was Barry Cheung. In order to trade in the futures, the Mercantile Exchange needed an authorisation from the SFC. The SFC is under a duty to protect the interests of the investing public in regard to products available for the public to invest in. And this includes automated trading services regulated under the Securities and Futures Ordinance. This was the type of service provided by the Mercantile Exchange. In exercising this duty, the SFC was empowered to impose conditions before the provider of the service could be authorised to operate its service. If the provider of the service at any stage, whilst the service was available, failed to comply with any conditions, then the SFC was empowered to withdraw the authorisation. At all material times, the relevant officers of the SFC were performing their public duties and exercising the SFC's powers as the market regulator. The authorisation was duly granted, and one of the conditions imposed upon the Mercantile Exchange was that it was obliged to demonstrate that it was financially viable, and failure to comply with the conditions would result in a review by the SFC, with the possibility that the authorisation would be withdrawn. Initially, the exchange was obliged to provide a monthly report to the SFC as to its cash position. This was to be supported by the current bank balance. It became apparent at an early stage that because of the time it was taking for the investing public to take up the shares, the Mercantile Exchange could not meet the original cash position condition, and later, after negotiations, the condition was amended so that the Mercantile Exchange was required to report to the SFC each Monday as to the cash position on the previous Friday, and had to ensure that the cash position demonstrated that the Mercantile Exchange had sufficient funds to cover its operating costs for the next 2 months. 2 months' operating costs at that time amounted to close to $30 million, which covered office rental as well as staff salaries. The problem was that the Mercantile Exchange was only generating income of $1 million to $2 million a month. There was no doubt that Barry Jeung was quite active in seeking further genuine investors, and so as to meet the conditions through his private company, New Effort Holdings, he regularly borrowed huge sums on both a long-term and short-term basis. In the meantime, the SFC regularly communicated with staff of the Mercantile Exchange, including Jeung himself, usually by email but also by letter and by telephone, reminding them of the need to comply with the conditions, and on 2 occasions, between May 2012 and May 2013, Jeung was issued with letters of mindedness to the effect that if the Mercantile Exchange did not comply with the conditions, then the authorisation would be withdrawn. The prudent thing to do would have been to surrender the authorisation, but rather than do that, Jeung continued to seek loans, and using Jackie Joy as the person to prepare often false and misleading documents to be submitted to the SFC, and simply lied to the SFC. Thus, through subterfuge and out-and-out lies, Jeung, with Joy's active assistance, kept from the SFC the true financial position of the company when the bank balance was at times as low as just a few $1,000s. The bottom line each week was the balance in the company bank accounts each Friday. A number of tactics were employed to create a bank balance that gave the impression that the company was complying with the financial condition. To give some examples, on 7 occasions, cheques for millions of dollars were deposited into the account on the Thursday or early on the Friday, which increased the credit balance on the Friday. Even though the cheques were dishonoured the next day, the balance at the bank at some time on the Friday was sufficient to enable Jackie Choi's department to show the SFC in the weekly report that the conditions were being complied with. Jackie Choi was specifically instructed by Jeung not to tell the SFC about the dishonoured cheques. Another tactic employed was to borrow on occasions large sums for a week or just a few days, again increasing the credit balance at the appropriate time. Having generated a bank balance which appeared to show that the Mercantile Exchange had the necessary funds, the sums were withdrawn and paid back to the lender on the Monday. Sometimes the deposits were not made in time, that is, the sums were not credited until the Monday. On those occasions, the Monday figure was provided as the Friday figure. Unfortunately, from an evidential point of view, documents generated by the bank were date and time stamped, which meant from a forensic perspective, the investigators were easily able to establish what had actually occurred on those occasions and the reasons for them. The bubble burst in May 2013 when Barry Jeung was conned by a con man who wanted to be paid up front a large commission for providing financial support in the sum of $30 million. The con man provided details of a bank account he purportedly opened with HSBC in the name of the Mercantile Exchange, showing a bank balance of $30 million. Jeung passed the documents on to the SFC. The bank account details were identified fairly quickly as forgeries, and Barry Jeung then surrendered the authorisation. Towards the end of 2012, New Effort Holdings had borrowed $80 million from a finance company. The share certificate for the sole share in New Effort Holdings was provided as collateral. In early 2013, Barry Jeung sought another loan of $30 million from another finance company and again produced an original share certificate for his share in New Effort Holdings as collateral. The loans on both occasions were obtained to prop up the mercantile exchange. Those facts formed the subject of the statutory fraud charge. Jeung had elected to give evidence at his trial, and in cross-examination he was unfortunately unable to explain how there were two original share certificates in existence for the same share. Coming back to the pre-trial events that I mentioned earlier, Jackie Choi had pleaded guilty before the scheduled trial judge to the conspiracy charge in November 2018. Initially, he had declined the prosecution invitation to testify, but when asked by the trial judge if he was going to testify, he consulted his counsel and then agreed to do so. The judge then asked the prosecutor what protection Choi would be given as, quote, "we all know what Jeung is like," close quote. His sentencing was deferred to the end of Jeung's trial. The judge's role was the subject of an application by the defence for the judge to recuse himself. I think the judge expected that I would oppose the application and appeared disappointed when I supported the defence position, the test being one of the perception of bias. In the event, the judge did recuse himself and a new judge had to be appointed. The victim of the fraud was the SFC. Much of the evidence consisted of various emails, both internal and external. The SFC had declined to provide some of the emails and provided others in a heavily redacted form, claiming that the documents were either subject to public interest immunity or legal professional privilege. The defence applied for disclosure of those emails on the basis that they were relevant unused material and thus disclosable. The SFC reviewed its position and handed over some of the material but maintained their stance in respect of the rest. A 3-day hearing ensued before another judge who ruled against the SFC on the public interest immunity documents but upheld the claims of legal professional privilege. Thereafter, the trial proceeded, and on the 17th of July 2020, Barry Jeung was convicted of both charges. There is no doubt that Barry Jeung was a man of previous good character and had made a considerable contribution to the community. Many prominent individuals, businessmen, politicians and others provided character references which were submitted to Jeung's sentencing hearing. Despite his standing in the community, on the 23rd of July 2020, Jeung was sentenced to 3 years imprisonment for the conspiracy charge and 2.5 years imprisonment on the statutory fraud charge. The judge ordered that 1 year of the second sentence be served consecutively to the 3 years sentence, and thus the final sentence was one of 4 years imprisonment. He was also disqualified from being a company director for 5 years. Because of the significant assistance he'd given in testifying for the prosecution, Choi's sentence was substantially reduced. He was sentenced to 1 year's imprisonment. Returning to Jeung, he had been declared bankrupt in April 2015 with personal debts in the region of $130 million. As I said at the outset, the rule of law is alive and well in Hong Kong. Before I become one of Saul's gunshot victims, I would just add that I hope to see you all in Cambridge next year. For those who have not had the privilege of attending this excellent annual event and who have an interest in economic crime, banking compliance or corporate governance, it is a wonderful event. It is not only an opportunity to do a little networking, but also to hear the brightest and best in their fields, practitioners, law enforcement officers, academics, judges and the occasional politician speaking about current and relevant topics. Come for the week or just a day or two, I'm sure you will enjoy what is sure to be a memorable experience. Thank you very much. Goodbye.